Anybody else has pen? For 17.
Impugn judgment and sentence is set aside. Appeal is allowed.
I'll approach. Please, Your Lordship. Lordship, I'd like to mention item number 6 of today's list, Your Lordship. Some difficulty today, Lordship, may kindly accommodate. What do you think? Item 6.
Today you don't have to mention
Lordship.
picking up if counsel doesn't appear. All right. When do you want?
Lordship, after 2 weeks. Hearing day, Your Lordship. Be taken up on a hearing day. Much obliged. Lordship, there's an interim order that may kindly be extended.
Interim order to continue till the next date of listing.
Yeah, please, my lord. My lord, I beg to mention item number 12, my lord. There is an interim, my lord. As per today fixed for CD, but Sarsit submitted lordship. Will appear lordship. Very good lordship.
Item number 12.
12 lordship.
Sure.
Lordship submitted.
Submitted that Harshit has already been submitted in the case. Learned counsel for the petitioner submits that the petitioner shall approach the learned trial court. Accordingly, this petition is disposed section that the here before the learned trial court within a period of 15 days from today. The event of filing any application, the same shall be considered as per law. Anything more needed?
May please, lordship, interim.
The interim order passed earlier shall remain in force for a period of 15 days from today. Or till appearance, okay, or till appearance before the learned trial court, whichever is earlier.
Pull 111 of
Must have list lordship.
कखनी लिखिले
Please, Your Lordship. So I have to mention item number 13, Lordship. Not available, Lordship.
13 CD not list again. No?
May I please, Lordship, I beg to mention 11, my lord. Please not there, my lord.
Is there not received?
So, yes,
Same
my
order.
lord. There's an interim order, my lord.
Okay, interim to continue.
Obliged, my lord.
May it please, Lordship. Lordship, item number 9 may kindly be adjourned for that day only, Lordship. May kindly fix after 2 weeks, Lordship.
Right.
Obliged.
Can't hear you.
Item number 1, Your Lordship. Kindly matter will be adjourned.
All right.
Bless you, Lordship.
May I please, Your Lordship? I beg to mention for listing one criminal revision petition, Lordship, for 11th of February, Lordship.
Go to senior bench.
The senior bench is not there today, not seated today, Lordship.
No other criminal bench is there today.
No, Lordship. Two benches is there. Pages will give.
Court number 24 is there. Then
Please, your lordship. The learned CGM convicted the petitioner under for 1 month under section 279 of the Indian Penal Code and for 6 months under section 304A of the Indian Penal Code. So thereafter, the petitioner preferred an appeal before the learned session judge. The learned session judge also confirmed the said sentences, upheld the judgment. And thereafter, this revision petition has been filed before your lordship. So this revision petition has been filed particularly on few grounds. So this is the delay in filing the FIR. There is 52 days delay in filing the FIR. There is no satisfactory explanation to that effect. Number two, the lordship, the other witnesses among the prosecution side examined altogether 7 numbers of witnesses, including the investigating officers. Out of 6 witnesses, PW1, PW5, 2 PWs are hearsay, and 3 PWs are relatives of the deceased. And PW3, he has stated that although he witnessed the incident, he claimed to be the independent witness, but he stated that he was not interrogated by police during investigation. Now, my lord, the record works LCR was called for.
thing is here.
That about, my lord, the doctor was not examined. Who conducted the postmortem report, he was not examined at the Planet Trial Court. My lord, these aspects were not considered by both the courts below. Therefore, this petition has been preferred before your lordship. Now, PW1 is the informant, he is the hearsay witness, my lord. PW2 is a relative of the deceased, claimed to be the eyewitness. He claimed that the deceased was standing behind a truck on the National Highway 37, and the offending vehicle knocked the deceased while the deceased was standing behind the standing truck. As a result, the accident took place. During cross-examination, PW2 could not even say the number of the vehicle and the color of the vehicle, offending vehicle. So his evidence cannot be taken to be trustworthy. Similarly, PW3, he although claimed to be the eyewitness, but he has, during his cross-examination, he has stated that he was not interrogated by police. So had he witnessed the incident, well, he would have been definitely examined by the police. Now, PW4 also hearsay, my lord. Now, PW5 also a relative of the deceased, and he also claimed to be one of the eyewitness. He stated that while the incident occurred, he witnessed the incident from about 100 meters distance. My lord, he further claimed that 2 passengers of the Tata Magic, that is the offending vehicle, also sustained injuries. To my submission, my lord, none of the passengers or injured of the Tata Magic were examined or interrogated by police. Neither prosecution examined either of them. Further, the alleged incident occurred in a highway, my lord. Vehicles are always plying on the road, And the PW5, he claimed that he stated that he witnessed the incident about 100 meters away, from the 100 meters away. Matlab, if an accident occurred in a highway and the said incident may not be visible, clearly visible from 100 meters away, my lord. So his statement is also doubtful, my lord. PW6, my lord, PW6 is the grandson of the deceased. And he claimed that he witnessed the incident from 15 feet distance. And he claimed that the deceased was going on a bicycle, my lord. The PW2, he stated that the deceased was standing behind the truck. And the PW6, he also claiming the eyewitness, he stated that the deceased was riding a bicycle. This bicycle was also not seized by police, my lord. So this contradiction, my lord, PW2 and PW6, although both of them claim to be the eyewitness, but their testimonies are contradictory to each other. One says the deceased, PW2 says deceased was standing, whereas the PW6, he is claiming that the deceased was riding a bicycle. That about PW6 further stated that during cross-examination, he reached about 10-15 minutes after the incident, rest the place of occurrence after 10-15 minutes. My lord, if he was at a distance of 50 meter only, then why he late to reach the place of occurrence? That is 10-15 minutes. Why he late? So, my lord, these are the contradictory statements of PW2, PW6, and the lacunas of the prosecution side. So, suppose doctor was not examined. So, my lord, the punishment is 1 month and 6
Why
months.
is the doctor required to be examined? Will he prove that he is not dead?
My lord, the deceased died, my lord.
Then
So the requirement is that, my lord, that whether this person was the deceased died due to the heat of the vehicle or something else, or by falling, like that. To that effect, my lord,
for
doctor
that
was
there is
supposed-
plenty of ocular evidence.
My lord, conviction, the case is of old ending one, only the
That is what you should not have come in appeal. You should have accepted the sentence of 1 month.
my lord.
Only 1 month, isn't it?
No, my lord, 1 month and 6 months. 1 month and 6 months. 1 month under section 279 and 6 months under section 304A. My lord, 304A. My lord, the PT cases, the government right notification number 2110-2020-22, all the PT cases were withdrawn by the government. But although this case, the judgment was delivered prior to that notification, my lord. During pendency of the criminal revision appeal, this notification was given by the
So
government.
we cannot apply that notification to you.
There is also option, my lord, in respect of the sentence, my lord, there is also option, my lord, the fine is also there. Now the petitioner, now presently he is 56 years.
Yes, prosecution.
Otherwise, my lord, there are three, my lord, eyewitnesses, PW, my lord, 2, 3, and 4, my lord, who clearly, my lord, stated that at that point of time, at the time of the accident, my lord, the driver of the Tata Magic vehicle, my lord, he was running that at that point of time in a rash and negligent manner, my lord, in height. Ultimately, that because of that accident, my lord, one victim, my lord, died on spot, my lord. And thereafter, my lord, otherwise from the material evidences, my lord, from the evidence of PW 2, 3, and 4, my lord, after going through the evidence of 2, 3, and 4, it reveals that, my lord, there is no infirmity in the order passed by the trial court, and the trial court has rightly, my lord, fuller evidence. Convicted the trial court has convicted the accused person, and thereafter, my lord, same was, my lord, affirmed by the appellate court, my lord. So, my lord, from
Yes, Amicus, anything?
Great with your lordship. And I appearing, there are some cases. One month or 2 months converted to fine, lordship, that applied in this as because lordship, the informant was served with notice and he did. And lordship, there is a notification also as per PT offense that can be withdrawn. This is a decision of our High Court, lordship, in 171 2000. Is 2 months punishment was there, the lordship. Fine. That can also be the conviction period, only 1 month, and
Was this a case of causing death?
Alternative punishment is also there. Fine is also there.
This was a simple case of beating by chappal. You are comparing it to a case where death of a man has been caused.
there also the imprisonment is for 1 month and 6 months. There it is a case of
We may hold that the learned trial court and appellate court has been unduly kind.
that prayer was from the accused side was there, lordship, in the page 26, lordship. That benefit was not the accused, lordship.
Anyway, this is a revision. We can't do a minute reassessment of the evidence. If only there is something glaring, then only we can interfere. Anyway, consider. Yes.
Obliged, lordship.
Very pleasant. These matters, they're connected. The first case is below for quashing the criminal proceedings, and second and third, anticipatory bail, which we have already got. The 4 petitioners before your lordship are internal auditors of Baroda, Bank Baroda, no? Bank of Baroda. There was some problem with regard to one of the managers, who is the husband of the complainant, respondent number 2 here. Well, it is like this, Milord. He was a manager here, then transferred to Jorhat. When he was a manager here at Gauhati, there were certain transactions which appeared, which were not regular and was touching the criminal law. Then he was transferred there, and there also similar problems arose. Therefore, they have a internal procedure for making investigation so far as these transactions are concerned. That was ordered, and these 4 petitioners are internal auditors. Their job is to inquire and report. And they did that. They found a lot of anomalies, and one which we are concerned with this matter, it was seen that the husband was the branch manager, he was the sanctioning authority. He used to sanction loans. The customers who had bank accounts, thereafter a portion of the amount is sent to the account of the wife. That was how Milord it was going. So that happened. Her case in the FIR is that she got married in May 23. Therefore, these were transactions which were before that. Partly she is right. There were some transactions before May 23, but major things are Milord after her marriage in May 23, which is there in the record. I'll show you a lot. So they inquired and they found that this is a pattern which has seen, and therefore, obviously, Milord, they submitted a report to that effect. Now, when that situation was there, the bank also wrote to the branch manager about this and asking for his comments. No reply came. So when they were issuing that notice, she has filed this FIR saying that her account they could not have investigated, and therefore there is all these offenses she has set out below.
Where is the policy?
From criminal breach of trust and all that, Milord. All the offenses was
17 to the.
section 61, then that is criminal conspiracy, then 316 2 criminal breach of trust, 336 forgery, then 340 forged documents as genuine, and 35 general explanations. So all these are part of the FIR filed. Therefore, we came first with the first anticipatory bail petitions, Milord, 2 each, 4 of them, and
Before registration of it.
before registration of the FIR, because on information on filing the complaint,
They
GR
said
case,
some
they
of the
issued
things.
notice, therefore they were apprehensive that they may be arrested, therefore anticipatory bail was prayed for and it was granted, and they are on anticipatory bail. Now possibly the charge sheet also has been filed.
Right.
Now, after the proceedings of anticipatory bail, we have filed this petition for quashing the proceedings, because no offense, even if you accept the FIR in its entirety, no offense is made out as far as these 4 auditors are concerned, because their job is to, they are appointed to investigate. The bank has authorized them to investigate. They have investigated and submitted a report. Now, as I show your lordship the details, your lordship will see that there are some transactions which are not explainable, and therefore it breaches the law. Therefore, we say that the FIR, even if you accept all its Milord allegations, do not make out any offense. So far we are concerned. We are auditors, Milord, our job is to audit and submit a report. That's our job. So by this kind of a method, you can't prevent investigation in a bank, which is, Milord, after all, a public institution with public money. So these things are not very healthy for the operation of the bank as well as for the other customers in the bank. So that is in sum total is the substance of the matter. And I'll place relevant pages, my lord, so that your lordship can have an idea about the whole thing and
Page
then.
17.
But if your lordships kindly turn to page 17,
70.
17, my lord. Page 17, my lord.
Yes.
Point 6, my lord, if your lordships kindly see. Two transactions of 25,000 each observed on 5/11/23. This is after May 23, my lord. With Vascosity Holloway, while UPI crediting account of Rima Datta. Rima Datta is the wife of the Millard branch manager, and he is the informant. And this is her account number, Millard in the bank. Was observed. One transaction of 25,000 observed on 8/11/23 with Sanjeev Talukdar, proprietor so-and-so, while EPI crediting account of Rima Datta observed. Then credits in the account of Rima Datta, spouse of Mr. Devopriya Datta. He is the branch manager, Millard. With borrowers of Fancy Bazaar branch with narration stamp purchase observed on 11/1/24, and these dates are given amounting to 68,000 and odd. Similarly, Millard, 9, if your lordship see, following cash deposit has been made in the account of your spouse, Rima Datta, from the branches where you remain posted. So this list is given, if your lordship sees, up to 5. These were prior to May 23. That is when she got married with the branch manager according to the FIR at page 59. And 6 onwards, these are all post. So this is what was found. And what is significant is, my lord, on the last column, your lordship sees, I have sent mail seeking version of the concerned employee reply.
You're on page
Page 17.
17 itself. Well, your filing assistant has filed this vertically instead of horizontally, so we have to turn our heads around all the time. Yes.
I'm sorry. My daughter has
Yes.
got it, Mulata. So reply not yet received. None of the letters were replied to, Milo. That's what is recorded. So this is 17. Then if your lordships kindly turn over. At page 19. Similarly, Milo, not received. No letter was replied to. And then, Milo, if your lordships kindly turn to page 26. Page 25, my lord, the family details are mentioned and the name of the complainant appears, Mrs. Rima Datta. And here earlier also the person concerned was warned, 21 and 23. There. And then, my lord, if your lordships kindly turn to page 26. This is Milord, the general manager, addressed to the general manager, general head, Bank of Baroda. And this is special observation letter. That is how it is called. Issuance of special observation letter on the first on Zanzibar. And details of the irregularities. First one concerns his wife. Suspicious transaction of 1.43 lakhs has been observed in the saving account number so-and-so of Mrs. Rima Datta from the borrower and customer account. Mrs. Rima Datta is the spouse of Devopriya Datta, senior manager. Suspicious cash deposit of 10.30 lakh or 1 lakh has been observed in the saving account of Mrs. Rima Datta from 3 branches, 6 Mile Fancy Bazaar, Gauhati, and Jorhat, where Mr. Devopriya Datta, senior manager, was posted. Details mentioned in the Annexure A. Then, Milord, the details given. Was this special report given? And then, Milord, if your lordships kindly turn to page 29. Number 5, Milord, at the bottom, staff transactions. On random checking of disbursement of personal loan accounts, the numbers are given. Milord, it has been observed that part of disbursement proceeds transferred to some common account holders, recipients, such as Goswami, Rinki Goswami, Rajiv Senapati, amounting to 232 lakhs has been returned back by UPI to the account of Mrs. Rima Datta, spouse of Devaprasad Datta, senior manager, and credit of the head of the branch from the account of Jadav Goswami, Rajiv Senapati, Kartik Dev. Details of the transactions are been specified. So that was the modus operandi, virtually. Transactions in the last part, transactions in the account of Mrs. Rima Datta, spouse of so-and-so, senior manager and credit head of the branch, have also been reported in SOL dated 22/25, already issued by the CMCID, right, so-and-so. That was already shown to you. Then, Milord, if your lordship 32, if your lordships kindly turn. This is a circular, Milord, to all branches and offices in India and abroad, issued by the Disciplinary Proceedings Department. So these are the guidelines for the office. Sanitization of staff towards misconduct, lapses leading to severe penalty and all that. And the nature of the misconduct. 4. Unauthorized debits in customers' account with subsequent credits in staff-related PC's account. He also large number of unusual transactions reported in staff-related accounts. In Miller 6, frequent operations and huge number of cash deposit and transfer transactions in SB account of employee, both self and joint account with spouse. Maybe a joint account or an independent account also possibly.
Okay, so it is only a report.
Report.
So what is her grievance now?
That is what I was trying to show. Once this is done, my lord, they issued a notice asking for replies and all that. He was not replying. Then he see as a counter blast, my lord, page 59 is the FIR.
Page?
Page 59 is our FIR. Before that, my lord, if I may just show the SOP, which your lordships will get at page 34. And page 35. What? This is a general SOP, my lord, keep quiet. Special audit. Audit. And page 35, if your lordship just have a look. In the second column, Miller, further verification of transactions in staff and staff-related accounts. So it is both. The staff may have an account or some relation may have an account.
Which part are you reading on page 35?
Miller.
Which part?
The first part, the second column, Miller. Second day from the commencement it starts, but further verification of transaction in staff-related accounts in coordination with offsite auditor. That is also within their domain. Then, my lord, if your lordship, just in the first column, what they can do is, first column, my lord, last but one, peruse and analyze the transactions in staff-related accounts and share adverse observations, if any, with on-site auditor for further verification. So the circulars, which are applicable all over India, indicate, my lord, that it is not only the staff, but staff-related accounts also can be verified by them. And that is what was done, my lord. That is why at page 35, your lordship has seen already the second column, further verification of transaction in staff-related account also. Then I was trying to list the FIR at page 59. Based with all this and the queries asked, and then the complainant, the informant moves me. And this is the FIR. Due respect, I beg to inform you regarding of below named persons who, being Bank of Baroda employees, had illegally accessed my personal savings bank account details and thereafter, with the intent cause injury to my reputation, had implicated my name in certain intra-bank investigation carried out against my husband, who is also an employee of the Bank of Baroda. The below named bank employees have accessed and implicated transactions which were carried out prior to my marriage. Your lordship has seen, and she has mentioned the date of her marriage as May 23. I need not bother your lordships about the prior to that. All transactions I have drawn your lordship attention is post May 23. These acts have been done with full intent and by conspiring to cause me harm. I have no relation with my husband prior to marriage in the year May 23. So, and therefore the persons named above legally could not have accessed my private details and then used them to me to malign my image and reputation and cause mental harassment. May I further bring to your notice that in communication issued to my husband by the Bank of Baroda, has details of the transactions those ensured prior to 23 May amplifying the fact that the below named employees with the intent to cause the injury to my reputation and otherwise has used said information. The bank employees being public servant and in fiduciary relationship should not breach the trust and cause me injury, and such act is outright illegal and calls for exemplary punishment. I, being a member of the Jorhat Bar Association and practicing advocate, has my own income and there are no transactions which are linked to my husband. Further, while the Bank of Baroda employees named below without even bothering to inform me once and with full impunity has recorded an implication of my name and intra-bank inquiry investigation for transactions which were prior to May 23. Such an action has jeopardized my career prospect and has also caused huge loss in reputation in a profession where the reputation is the real currency. Their act has also infringed upon my privacy, and this was done intentionally. They have additionally conspired to fabricate my transaction details as per their convenience so as to cheat the management of Bank of Baroda in believing that some untoward incident has taken place and implicated an intra-bank inquiry investigation in the said matter. Therefore, in the above background of facts, I would like to pray before a good office to take appropriate action against the persons named below, for they have infringed in my right to privacy, falsely implicated me for my acts, which has no connection with their investigation, conspired against me, forged documents, breached my trust, misutilized their authority, caused loss of reputation, and defamed. Further, may I bring to your notice that the act has been done only to cause mental harassment to me, knowing that I am in advanced stage of pregnancy. Needless to say that the intent of the below named persons are only to cause trouble to our conjugal life and pregnancy by causing unnecessary stress. While there may be personal enmity with my husband, of the below persons have no right to cause trouble to my life and my right to bear a child without trouble, and also deliver it safely. Therefore, I further urge that your good office may take note of their intent to cause harassment to me and to inflict unnecessary complication to my life and my right to be a mother without trouble. The intent is clear from their act of considering transactions of my own account prior to marriage for investigating my husband and then malign my image by leveling me in the said realm of doubt. I also fear that below named person might use the personal account details with others and other public forum to cause me further loss by causing threat to safety of my hard-earned money and also to my life as a. That is what the FIR is. Substantially, Milord, she was emphasizing on the details prior to May 23, which, as your Lordship has seen, even if you remove those, post May 23, there are enough transactions which have been noted and which has clearly indicated. And the fact that queries were not responded, no reply came, aggravates the situation further, my lord. And if what she is saying, my lord, she is not denying the transactions and the transmission of amounts from accounts pension to her account, and after getting loan and all that. Therefore, my lord, if it has to be accepted, my lord, it will virtually mean that although the facts are not denied, yet you can't touch the person concerned. Then, my lord, the whole idea of the institutional integrity of the bank, all those details that not only the staff account, but also staff-related accounts, they have a obligation to see, because this is kind of an offense without which no bank would like to continue and make it public, because after all, a bank is also, on the basis of a public confidence. So in these circumstances, whether, my lord, assume all the facts, allegations in the FIR, whether any of the ingredients of these 4 or 5 sections, my lord, have been satisfied. Humble and respectful submission, my lord. If your lordship can just see the offences, your lordship know it, my lord. Your lordship with that. 61, this, my lord, criminal conspiracy. Nothing, these are, my lord, the persons concerned are auditors. If they don't do a proper job, they will lose their job, basically. And they have no personal interest in the matter. They were asked to investigate, which letter is also on record. The additional affidavit, we have said that they are page 68, my lord. They were asked to investigate, and their job is to investigate. Otherwise, what will they do? Page 68, additional affidavit, your lordships will find on this.
Additional affidavit.
Yes, please. 60, page 68.
Yes.
Assignment investigation from Bank of Baroda on behalf of Ziad, Northeastern Zone. Ziad means what? Ziad, Z-I-A-D.
Zonal internal audit.
Zonal Internal Audit Department, Ziad. So to the petitioners, this is the letter. And say, please find the attest SOL, Special Observation Report, which your lordship has seen earlier at page SOL 26 or 29. 26, I think. And please find a test SOL of Fancy Bazaar branch dated 22/25. Please note the instruction for investigation in the letter. Looking to the serious nature of irregularities reported as above, this special observation letter, SOL, is being issued with following requests. Here, NES to arrange for in-depth investigation on the matter and cover all the credit facilities and sanctioned during the period from 22 to 24, where Mr. Anand Kumar Singh so Chief Manager, and Mr. Devopriya Dotto, Senior Manager, were posted as branch head and credit in charge respectively, and also examine lapses on the part of the continuing office. Requested to carry out the investigation as per scope of the letter starting from 10/3/25. The allotted mandate is so and so days, and submit your report.
This is page? Page. This.
Page is 68, Miller.
Right.
Additional affidavit. Miller.
Okay, I've read that, yes.
Yeah. This is the, Miller, direction to the auditors. And they have investigated, and while the other anomalies were surfacing, they found this also, because they are required under the SOP to see the stuff related accounts. And that was something which obviously without attracted their attention, because you get a loan from the bank, receipts are put into their account, and within contemporaneous time, you give a portion of that to the account of the wife of the credit sanctioning authority. That is the branch manager thing. Obviously, my lord, they have to report that. And if it is done, my lord, you can't say that your accounts have been, I could have understood that these are the transactions, these are the amounts. You were given notice, your husband, nobody replied, as your lordship has seen. Several letters were given. So in these circumstances, my lord, her allegation of harassment is absolutely misplaced because these people have no interest. They were authorized. They are the persons who are supposed to do the audit. They have been asked to do the audit. They have done that. They have found other anomalies, and then this also attracted their attention, and they submitted a report. And that was not even replied by the manager concerned. Therefore, my lord, in my respectful submission, these offences which are alleged, if I may just, your lordships are familiar absolutely. 61, criminal conspiracy, my lord. I don't have to read out to your lordship, my lord. Then 316 to criminal breach of trust. Whoever being in any manner entrusted with property or with dominion over it dishonestly misappropriates or converts. I mean, the whole, my lord, the tenor of these offences are different. These facts can't be invoked by the person concerned to make allegations against those who are investigating. Therefore, my lord, in my humble submission, the ingredients are absolutely missing and no offense at all has been made out by carrying out an investigation. And if they carry out an investigation, whatever is found, which is not normal, my lord, they will have to report which they have done. Then 336(3), forgery. Similarly, my lord, what is the element of forgery? I have done nothing. We have gone by the record. We have 336. Whoever commits forgery intending that a document or electronic record force shall be used for the purpose of sitting shall be punished with imprisonment. What have I done, sir? No allegation in the FIR. Absolutely unthinkable. And then 340. Forged document or electronic record and using it as genuine, a false document or electronic record made wholly or in part by forgery is designated a forged document. You make allegations against the investigator about forging documents. The record is there, you are investigating, you have found, and you have reported. And you, for that, you can't be dragged to the criminal court and made to go through that process. In my humble submission, my lord, these alleged offences on the facts of this case, no offence at all has been made out, and it will be an abuse of the process to allow that to continue and to be drawn into that kind of a litigation. Therefore, in my respectful submission, my lord, the proceeding needs to be quashed because satisfies all the requirements. Your lordships know, my lord, the just give the reference for your lordship. No, I am only giving the reference. 92 supplement 1 SCC 335.
Pass over a copy. Just pass over that copy.
Oh, yes.
Not note it separately.
Yes. Lal's case, as your lordship note, in paragraph 1022. Given the cataloging, the grounds started from 1960, that Kapoor's case, my lord. There is no offense made out, then it's an abuse of the process to allow that criminal process to continue. A good summary here. And page 378, my lord. This is 92 supplement 1 SCC, page 335. 92 supplement volume 1 SCC 335 at 378 paragraph 102, the summarized and the grounds given as your lordships know. My lord. This first one, my lord, where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out against the accused. And my learned friend wants me to read 7 also. Where a criminal proceeding is manifestly attended with malafide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. It almost borders on that, my lord, because they were given the opportunity, they are not replying, and now you are. And they have filed the charge sheet, and there is a judgment, your lordship. It will be there, the copy. This is 2019 11 SCC 706, my lord. That even if charge sheet is filed, court can go into the quashing of the FIR because no case has been made out. That is that it aggravates further. That's what it says. Paragraph 14 to 16. 14 to 16. At page 712, my lord. Reference is 2019 11 SCC 706 at 712 conclusion. So these are my humble submissions, my lord.
Prosecution.
Yes, my lord. In this case, my lord, we are received, my lord, and along with the TCR, my lord, I have also found the my lord, case diary of the case, my lord. And although search sheet submitted, the original in case diary is also with me, my lord. I will hand over the CD to your lordship, my lord, because some of the statements, the accused person that is not available in the TCR, my lord. And regarding the, yes, my lord, in the present case, the on allegation against the petition, all the petitioners are the, my lord, audit team of that Bank of Baroda, my lord. And regarding the, my lord, allegation by the informant is that these accused persons, my lord, while, my lord, conducting an investigation, whose informant husband is also an employee of the bank, then during that, my lord, investigation, they also unauthorizedly assess the account of the informant, my lord. And for which, my lord, informant was she mentally harassed, and because of that, my lord, she has lost this FIR against this audit team, my lord. And while filing search sheet, my lord, against one person, my lord, he is also a petitioner, my lord, in the criminal petition, my lord. Samim Riaz, my lord, against Samim Riaz, my lord, search sheet was not filed, my lord. It was not sent up for trial. Samim Riaz. He is petitioner number 3 in, my lord. Criminal petition number 1103. 2025. My lord, here in the my lord, TCR's case diary also there are a statement of 6 witnesses. My lord, informant statement of the informant is also available. My lord, as per the those, my lord, investigation regarding, my lord, that, my lord, some fictitious transaction that was going on in Bank of Baroda that relates to, my lord, as per the estimate that relates to in the of the year 2022, and the marriage between the petitioner and the accused solemnized on 6th May of 2023. So, my lord, on that basis, my lord, the audit team has no authority to, my lord, that is the allegation that run into those, my lord, transactions.
No,
my
even
lord.
if they are to investigate the post May 23 transactions, they will have to access the account.
Yes, that
Once
they
they
can,
access the account, everything will be out
yes,
anyway.
there is no but, my lord, in accessing
Can
those.
shut their eyes from the top of the screen.
Yes.
It will come out everything.
Yes, yes. And my lord, in their statement, my lord, accused person also stated that they have no allegation against the present petitioner. They have simply, after my lord investigating the entire case, they submitted the report because there are some allegations against the husband of the petitioner who is an employee of the bank. What he has done, my lord, those are the aspect of that other case, my lord. During, my lord, while he has, my lord, granted loan to some of the customers, thereafter immediately after issuance of those loan, some of the amounts directly transferred to the, my lord, account of the, my lord, the present petitioner and the account of some other persons. Regarding those are the aspects of that case. And while those, my lord, loans were granted, my lord, allegation that some of the, that is the, my lord, petition, my lord, that some of the my lord, money, my lord, immediately after granting of the transferred to the account of the informant, my lord. My lord, that is the, my lord,
Those are the findings of the audit team.
those are for that, my lord, separate, my lord, investigation by the, my lord, audit team of the investigation. That is, yes, that is true. And, my lord, in their statement also, accused person clearly that, yes, my lord, we have no allegation against the present informant, but for the purpose of investigation, we have investigating the case, and thereafter we have submitted the report, my lord. But, my lord, there are some of the witnesses of the, my lord, their statement. I have, my lord, flag mark in the
Saying what?
yes, saying that, my lord, yes, he was mental because of some personal, my lord, reasons, my lord. Those, my lord, persons tried to, my lord, vindicate the present husband of the present petitioner, and, my lord, unnecessarily, my lord, they are trying to mentally harass the informant of the present case along with her husband. So
No, who are the witnesses who would know such a thing?
those are their statement, my lord, because that is there in the, my lord, TCR, my lord. And on the ground is that, my lord, she was mentally harassed by unauthorizedly assessing her account, while, my lord, my lord, investigation was going on in respect of her husband. So, my lord, prima facie,
Could you dwell on the point of unauthorizedly?
yes.
Is there anything to indicate that this was an unauthorized accessing, despite they were acting under the directions of the bank, isn't it? That's on record.
My lord, it cannot be said, my lord, at this point of, yes, my learned senior has
At
rightly
which point can
pointed
it be
out
said?
that, my lord, unauthorized access, yes, during investigation, while investigating a particular matter, while her husband is in fact involved in, my lord, all these suspicious transactions, while the investigation, for the purpose of investigation, my lord, yes, they can investigate in every aspect of the matter. If some money transferred to the account of the informant, there is no bar in investigating, my lord. While, my lord, to find out the truth, the, my lord, audit team can investigate the, my lord, entire aspect of the matter, my lord. And regarding that, my lord, causing mental harassment, yes, some of the, this is because of some personal reasons, my lord. Those audit team person, those aspects, my lord, also need to look into what are these, my lord, personal reasons for which later on, my lord.
Pass it over.
I am handing over the case there, my lord. The statement of the accused person is not there in the TCR, my lord. Here.
CV.
Problem.
Because before Lordship, my lord, he lost an FIR against his wife and daughter, my lord. What happened while obtaining the admit card, my lord? They have forged some documents, my lord. His identity cards. And name is Haider Ali Fukon was written there, my lord, in the documents, my lord. When he came to know, my lord, he lost an FIR, and FIR subsequently, charge sheet was submitted. Those sections of forgery was not there. And he made an application under section 156(3) before the learned judicial magistrate, my lord. And on our trial court, my lord, by the order dated 14/5/2025, your lordship had pay lecture 4, page 31. Allowed a detailed order, it was done, my lord. The notice was also issued to the informant, my lord, to the accused persons. And subsequently, and this honorable, the trial court, my lord, that That from the case that it appears that the investigator has recorded a statement of 4 witnesses, including their informant. The statement of witness number 1, concerned register of his birth and date, registration, Department of Health Services under Kakojan PHE, principal of Jyoti Vidyapith, Jog, as mentioned in complaint, this is where the forgery has taken place, were not recorded. And documents relied upon by the informant mentioned in the list of documents in the complaint were never seized, not verified by the investigating officer. Page 49. Having scrutinized all the facts and attending circumstances of the case, satisfactory grounds warranting further investigation. The case, and therefore I found it prudent to direct the officer in charge of your police station to conduct further investigation in terms of section 173(8) of CRPC oblique 193(9) of the BSS. Accordingly, OC was directed to conduct further investigation in terms of section 173(8) and submit a report so and so. Now, this order was under challenge before the Honorable Session Judge, my lord. And it was transferred to Court of Additional Session Judge. And while order that impugned judgment 28/8/2025, this petition was allowed. According to the revision court, my lord, there was a delay in approaching the because they knew it way back in 2015, my lord. Only in 2022-24 it was live. There you will also find that the finding of the revision court, my lord, I'm coming to the finding, but since the paragraph 51, page 51, paragraph 20, my lord. Here a prime question before this court is whether the order of further investigation of the order, said order, is illegal, incorrect, improper, irregular. In my considered view, since the complainant knew the fact of changing Hyder Ali to Hyder Ali Fukon beginning in 2015, when he was sleeping till 2024, subsequently complainant came forward to further investigate the offence under 420-468. There is no explanation provided by the complainant why he remained silent for so prolonged period. Honorable Appeals Court mentioned clearly the inordinate delay may be condoned if the fair trial demands, but unexplained inordinate delay must be taken into consideration while passing order for further investigation. In this case, complaint has not made any whisper of such inordinate delay, whether complaints conduct does appear to be fair to this court to allow further investigation. Therefore, I find an impugned order passed without taking into consideration the fact that inordinate delay without any explanation, trial court has passed the order warrants interference. So now my first question before your lordship, my lord, it is a revision court, my lord. Revision court was accessing power under section 397 and 399. He has to confine to the legality and validity of the order. Whether there was delay in approaching is a question of trial, appreciation of evidence, my lord. Whether I have mentioned in the FIR or not, it's a question of evidence. They have to cross-examine the witnesses, my lord. How the revision court can come to a finding that you approach since you approach it delay, so I cannot order. The Royal Minister cannot order for 156(3). The approach is totally illegal. It's not permissible under section 397. Because, so she exceeded his jurisdiction, man. That is my submission. He admitted that yes, the power is there. But since there was delay in approaching the authority, so he knew it was 2000, after 4 or 5 years, 9 years, he has approached. So there's a question of fair trial. But trial has not yet started. Where is the question of fair trial will come? Unless there is no investigation, the materials were collected but not seized. After material, if the final report may be given, we don't know. After seizure, after comparing what forgery has been done, nothing has been unearthed. So in order to bring out those materials, that they are further investigation necessary. Now, question of fair trial will come later on. So my humble submission before your lordship, my lord, the learned Honorable Session Judge, my lord, while passing this order, has exceeded his jurisdiction. And in fact, there are Supreme Court decisions, as your lordship also aware about 397-401, my lord. There is a settled principle of law that one decision that there is 1987 Supreme Court, and reading the law, my lord. The section 397 provides the High Court or Court of Session may send a record to inferior compelled court for satisfying about the correctness, legality, and propriety of any finding, sentence, and order passed as to regularity of any proceedings of inferior court. Therefore, it clearly indicates where court calls for a record to exercising power under section 397 expected to examine the records of our purpose of satisfying itself about the legality and propriety or correctness of the order, about a regularity proceeding. But he cannot go behind the order and say there was delay in approaching the informant has approached the after 4 years. So you cannot investigate. It's a question of fair trial. So my humble submission is that this order requires interference. It will like to liable to be set aside. This is my this.
Well, in the impugn order, my lord, when it is passed, my lord, they're relying on some judgment. Otherwise, my lord, my learned senior has already submitted the matter. That part, my lord. My lord, that is in page, my lord, 50 of the, my lord, that is petition, my lord. The one, my lord, that is authority, my lord, when my lord, the learned additional session judge, my lord, relied is, my lord, Rampal, Gautam, and others versus state. Again, in my lord, in para 19, my lord, that is the Bharat Redry and others versus C. Sunil Kumar and others. And another one authority, my lord, Hasmukhlal D. Vora versus state of Tamil Nadu. Regarding that, my lord, delay part, my lord, while my lord passing the, my lord, that order, my lord, this order. On that part. Otherwise, my lord, rest part is there. Here only the delay on that part, my lord. Now, my lord, learned friend is
One thing I would like to understand,
my lord.
was an order allowing further investigation, wasn't it?
Yes, ma'am.
Yes.
Allowing further investigation. The question of delay relates to the date on which the FIR is lodged.
Yes, ma'am.
My lord.
That part is over. FIR was lodged, it was investigated, charge sheet submitted.
My lord.
Then this further investigation order was passed.
Yes, ma'am.
That is under challenge in the
Yes, my lord. That was,
revision.
yes, my lord. Thereafter, my lord, they
But
filed.
delay relates to the lodging of the FIR,
My lord.
not to the ordering of the further investigation. It was not a quashing petition.
Not a possibility.
It was confined to the impugned order passed by the
Yes,
magistrate. The question of delay would not arise there in
Does not
that
arise.
context. Anyway, let's see.
Learned.
Otherwise, also, there is no bar in making any further investigation. So, the only thing, my lord, which the learned court relied on is the date of making the initial complaint before the magistrate seeking registration of an FIR. Because if the complaint is seen, there is no specific dates and regarding when he came to notice about this forgery and all. And the documents which were relied on by the accused in the revisional court regarding filing of previous cases, it also shows that those cases like divorce cases were initially filed in the year 2015. So perhaps there was some kind of delay while making filing the complaint seeking registration of the FIR. But regarding, my lord, the further investigation part, my lord, that
If he was
Yes.
aggrieved by the
Yes.
delay part, then he could have come for quashing.
yes. And it is the discretion of the court whether to grant
Yes.
further investigation or not. Court will examine whether the discretion was exercised on proper consideration of not or not.
That is not what I am supposed to consider
Yes,
now.
yes.
I am supposed to consider
Yes.
legality of the
Yes,
revisional
that-
order.
that much.
Otherwise, I will be committing the same mistake as the
Yes.
revisional court. Maybe.
Item number 8, my lord, on earlier occasion, my lord, PCR was, my lord, called for, my lord. As per office note, my lord, that is not available, my lord, is awaited, my lord.
PCRS call for has not been received. Issue reminder again on.
Earlier interim order that may be continued, madam.
Yes.
Earlier interim order that may be
Earlier
continued.
interim order passed earlier to continue.
Public.
Council is present. No, council. Maybe in another.
May please your lordship. My lord, in this case, my lord, TCR was called for along with CD, my lord.
My lord, this year received, my lord. Here,
The petitioners herein are all, my lord, absconder as per the charge sheet, my lord. And my lord, they willing to proceed with the, my lord, case before the trial court, my lord. And since the case is, my lord, is a sessions tribal case, my lord. My lord, my lord, the learned judicial magistrate, my lord, has no power to, my lord, entertain their bail application, my lord. That is why they prefer before your lordship, my lord. The, my lord, land dispute and the petitioners are neighbor, all are adjacent house, my lord. They are residing peacefully at present, my lord. Basically, my lord, quarrel, also, my lord, oral quarrel, my lord. It's not, my lord, the quarrel as alleged in the FIR, my lord.
No, so what do you want now?
My lord, petitioners are willing to cooperate with the proceeding, my lord. Only, my lord, there may be grant bail, my lord.
Well,
When a session tribal case, 307 is there, my lord. Life conviction is there, my
We
lord.
have to grant bail on merits, then we have to call.
Well, any condition, my lord, there, my lord.
my lord. Here, my lord, we have received the second copy, my lord. Here, NB after bailable warrant of arrest was issued, my lord, against him.
After?
Bailable warrant of arrest was issued initially. Thereafter, my lord, after execution also they have not appeared, my lord.
Look, they have already
Then
engaged their
NBW was issued against him, my lord. And during the investigation, they have not cooperated with the investigation, and in the search sheet, it was they were declared as absconder, my lord.
the petitioners were never charged by the police, my lord.
Against accused number 1, he is no any, my lord. 2, 3, 4 was search sheeted, my lord. All of them.
And relying, my lord, to judgment, my lord. In that situation. But there
And
is
next
session
date is
tribal
fixed
case.
for 4 to 26 for appearance, my lord.
Well, we can only protect it till appearance
My lord, that is my lord.
before the magistrate.
Otherwise, the judicial magistrate will not entertain their bail, my lord.
Yes, we have to go on merits.
My lord, kindly see the, my lord, the criminal petition 53 of 2020 is, my lord, recent judgment, my lord. 21/1/2026. Here, my lord, the honorable considered the bail as the, my lord, the case is a sessions tribal case. Para, my lord, 4, my lord. And my lord, the four persons are declared absconder. That is the petitioner's, my lord. In Supreme Court, my lord, para 10, my lord, 9, 10, and 12, para 10.
I have also flagged some witnesses, my lord. Eyewitnesses, my lord.
The nature of the offense is also to be taken into account. It is not that in every case you, NBWA you remain an absconder
Right.
and NBWA issued, you come to the High Court, say we'll appear and get bail. Will that be so even if you commit a murder?
There is also 307 is there.
307 is there.
And everybody will just avoid and then come
Then
say.
come to Madras High Court and for bail.
This case in the Supreme Court, this was not a serious case. It was some kind of financial transaction was there.
But in the matter of the criminal petition, my lord, this is my lord, the Sessions tribal case, my lord. My lord, this is also a Sessions tribal case, my lord.
Maybe Sessions tribal cases are of various nature.
They are neighbors, my lord, and adjacent household.
Medical report is there.
My lord, no medical report is there, my lord.
No medical report.
My lord, but one discharge form was there, my lord. Here it was, he was admitted on 22/9/2013, my lord, and discharged on 25/9/2013, my lord. Head injury, my lord. The discharge certificate is mentioned head injury.
Injury can also be simple.
That is this. But in the
There is no fracture. It is
but
contusion.
but it was in the vital part of the body, my lord. That may cause also death to the person also, my lord. That's why perhaps 307 is there.
He was discharged within 2 days.
My lord. 3 days, my lord. 22/9/13 and 25 discharge on 25. 3 days. But otherwise, witnesses also implicated, man. Witnesses also implicated, man. They have assaulted person. Eyewitnesses is there.
The immediate question is whether everything is over, so whether they are to be taken into custody. The purpose of the trial.
So the dispute basically the accused number one and the informant brother, my lord. The petitioner's name involved in the just because they are the family members of the accused number one.
accused number one already discharged from the minor
Yes.
in the charge sheet manner. But others are in the implicated manner.
Then
And
FIR
the
and the
charge
charge
sheet
sheet, my lord,
submitted-
conflict there is a my lord.
Hmm?
FIR and the charge sheet, there is a conflict, my lord.
The deceased person is also before us.
Not different.
His name was not charge sheeted, my lord.
Yes.
It heard learned counsel for the petitioner and learned an application under the charge sheet has already been submitted. Submitted showing the present petitioners as absconders. Currently, PWA has been issued against the petitioners. Submitted that since the case is sessions triable, the petitioners apprehend that upon their appearance, they will be remanded to custody. As far as the facts of the case are concerned, the course of an altercation, the petitioners assaulted the informant side, causing with sharp weapons, causing serious injuries. Medical, a discharge certificate available, that TCR in respect of one injured person. It's that he sustained a head injury, was hospitalized for 3 days, for which he was discharged. But there is no indication that the injury was grievous in nature. Having regard to the nature of the allegations, fact that the investigation here that is not necessary that the petitioners be taken into custody for the purpose of the trial. Learned counsel for the petitioner has relied upon a decision of the apex court in Mahdum Bava versus CBI 2023 SC online SC 9. Then, after considering the facts of the case, the court had held that the appellants therein were entitled to be released on bail. Having considered the facts and circumstances of the present case, I am of the view that are entitled to be released on bail in the event of the court choosing to remand them to custody when they appear in response. In response, appear before the said court. Accordingly, it is directed that the petitioner shall appear before the learned trial court on the next date fixed. That is,
Earlier
Lord,
4-2, my lord. Then next date is there.
okay, on the next date fixed. That's appearance. May be released on bail upon such terms and conditions as may be imposed by the learned court below.
4-2.
Let me hold on.
Petition stands allowed accordingly.
But in this case also, my lord, the scanned copy of TCR was called for, my lord.
Can could be received, my lord. It was
Similar, my lord.
some difference is here, my lord. Here they have assaulted a police personnel, my lord. 12 buffaloes were recovered from their position, my lord. Is them, my lord, and taken to the, my lord, under all of them, my lord, 15, 20.
My lord,
And during the investigation, they have not cooperated investigation and search sheet submitted, showing as them absconder, the search sheet, my lord. And police personnel who have filed the FIR, my lord, here is report also there, my lord.
What is that injury?
Here simple blunt also. But here, in exceptional condition, my lord, assaulted the police person.
Your police can't even find the very persons who assaulted them.
My lord.
They submitted charge sheet as absconder.
My lord, they are not, my lord, their names are there, my lord, during the investigation, witnesses are implicated.
Oh,
And
why
who
couldn't
is-
they catch them?
That is different thing, my lord. Police, they have played away, my lord. How they will.
You
Police.
can't even protect yourself.
All the person assaulted, my lord. All the they are gathering with.
Oh,
15,
that
20
is why. How will you find other absconders when you can't find the ones who are assaulted you yourself? What is the name, petitioner?
petitioner is the, my lord, Dudbor Sheikh.
Dead body.
Total 6 accused. Out of 6, my lord, 3 are arrested during the investigation. They were released subsequently. And 3 are, my lord, declared absconder. Out of 3, petitioner is one of them. And 2 absconder were released pre-arrest bail by order dated, my lord, page 47, 22/9, 2022. 25 minutes. And the petitioner also filed bail. His bail was granted only on the basis that this case is a, my lord, sessions tribal case. Page 50, last page, my lord.
Bail was granted.
Petitioner bail was rejected only on the ground that the case is a, my lord, the sessions tribal case, my lord. Tribal by session, my lord, last page, page 50, my lord. That is why the petitioner withdrew. Otherwise, he is willing to, my lord, cooperate with the proceeding.
Is this case page 44? This is arising out is a co-accused.
My lord, all are co-accused. 6 accused are declared as, my lord, accused person as per charge. 3 arrested during the investigation and 3, my lord, declared absconder. 2 absconder or PDS bail granted, my lord, by the order dated order 22/9/2020, page 47, annexus 7.
Page 44, dated 18/3/25. Para 1, 2, 3 নাম তো চেঞ্জ করব। What is your occupation, businessman?
My lord. My lord, petition is a daily wage earner, my lord. Daily wage on a laborer, my lord. There are two, my lord.
What is your defense? You are not present.
My lord, the petitioner was never charged, my lord. During the, my lord, all the past years, my lord. Petitioners were never charged by the police during the all
Oh,
past.
no, even were you present at the time of the incident or not?
No, my lord. He was not present, my lord. Just he's a co-villager of the other accused, my lord.
Para 3 up to bracket. Order submitted that the petitioner is a daily wage laborer and he is no way connected with the alleged offense. A co-accused of the present case was granted bail by this court by order dated 18/3/5. Bail application 551 of 2025.
There are 14, I have given the charge of bail.
Now NBW has been issued against you. বাকিখিনি আগৰটো দৰে text totally এইটো just bail application preferred by the present petitioner, the learned additional CJM, rejected by order dated 22/9/25. As the case is exclusively triable by the Court of Sessions. Hence, the petitioner has this court.
Any oblige, your lordship.
None appears as per office note. Fresh notice was issued on the respondent number 2 by speed post on 4/12/25, but AD card or unserved notice has not been received back. With service. What to do with the case diary? Case diary be returned for resubmission on the next date. Or we'll call for the case diary once the service. Yes. Line to Katidiba to be resubmitted to Hidakati. Yes. Return. He can let again. Part 2 होने लो करो.
My lord, it seems CBI counsel is still, I think, preoccupied with her hearing.
So let's have it another day, or you want to do your part?
I can do my part if honorable court allow. Because of the fact that basically here, our contention, my lord, our basic main contention on the ground here is the non-compliance of section 48 of the BNSS, followed by other grounds, which are also very much important considering the aspect of the case and the stage of the case. This particular matter, your lordship, pertains to the Paltan Bazar PS case number 288 of 2024, which was registered against the accused and other co-accused in relation to the trading scam, where this particular petitioner has been arraigned as the main accused, as the mastermind. Now, this particular accused was arrested from Goa in another case. When he was arrested from Goa, he was brought back to Gauhati. Then he got the Assam police got his custody, and in that way, CBI, when this case was later registered as CBI case, CBI got the custody from the jail authority. Now our main contention is that CBI are saying that they have complied on the provision. They have served a 47 notice to him in this particular case, but they do not have any prior knowledge that whether 48 notice was served in that case when he was arrested. They do not have the knowledge because that was a different case. Now, in this particular case, they have served him the notice. But at the same time, they are also saying that they have served 48 notice in this case to someone, an employee. Now, our contention is that who is that employee? Whether they have recorded particularly the relation of the employee with the accused, which is very much the mandate of 48, which has been already taken care by the Vihan Kumar judgment.
That can only be revealed by their CD.
Absolutely.
Whether-
So CD is important. At the same time, to what extent that particular serving of the notice.
And secondly,
Yes, fine.
although the case number after being taken over by the CBI would naturally change,
Yes.
the case is the same.
Yes, Paltan Bazar PS, it
Yes.
has changed.
Case is the same.
This is the
So
same.
initially, if 48 was complied with, there is no necessity of second
No, no, no.
compliance.
That is a different case. That was in Paltan
You
Bazar
said they
PS
take,
37.
CBI has taken over that case.
No, that has not been taken over by CBI. That case. In
So
that
he is
case,
shown arrested.
yes, he was shown arrested in this case. That is Paltan Bazar PS 288. He was later shown arrested by in this particular case by virtue of that arrest in 374. Now our contention is that if CBI has
So as things stand now, 47 is complied with.
yes,
48 they say that it is complied with, but your contention is that it has been given to the wrong person.
person at the same time whether it has been fully complied or not, and whether all the ingredients and the requisites
Fully complied with means where is that? Where is that?
Pardon your
48, 48.
40 they have not given anything. We do not have found it in the record. Now they have to submit how they have served it and whether that person who has received it in real sense or not.
Yes. Is it available?
CD is available.
We want to see the 48 notice that you say you have served upon his employee.
I'm bringing that CD.
Because infringement of that particular requirement is very much important. Because this 48.
We don't know, you may have named him as the nominated
they
person.
have himself they have admitted. The accused have not nominated. He has not notified any person. In their objection, that is why very surprising. Let us go with the objection, my lord, if allowed.
Objection starts at page.
Page number 189. They start with 189. And what are their contentions, my lord?
Argument.
वो कोई हमको कोई
Which part of the objection? Where is stated?
Para 8, my lord. That is page number 198.
198.
Page number 198.
What two? Para 8 is in page 192.
198, my lord, of their objection.
Yes. I think they have renumbered the paras.
Yes, yes. 198 para 8.
Now it is 28. That the averments made petition in paragraph 13 are wrong. That one.
Yes, ma'am. The lower portion will come now. My lord.
Yes.
During the this one, starting from we come down to the last thereafter.
He was accused during custody. Accused petitioner did not notify any relative.
Yes, of his arrest. However, his arrest was informed to his known employee of the firm. Therefore, there is no violation of the provisions of section 48 of the BNSS. It is further submitted that CBI does not have any knowledge about the compliance of the provisions of 48 of BNSS by Assam Police in the case number 373 of 24, in which the accused petitioner was arrested from Goa. They do not have the knowledge.
That is a different case.
Yes, different case. But the numbering is wrong here. FIR 374, it should be FIR number 374. They have stated here 373.
Maybe clerical.
Yes,
mistake.
clerical, typography.
It is.
So now our main contention is that if it is fulfilled, then it is, we do not have anything to say. But since we have not come across that particular record and that particular notice while we have perused the court record, that was the contention taken from the petitioner side, because petitioner didn't know who was informed, and the main thing was
Petitioner is Dipankar Burman.
that yes. So now
So Dipankar Burman, son of Sri Chabin Burman,
And
resident of flat number 4C,
Yes,
you could not have served to him.
Yeah, he has received.
Then you state in your objection that it was we did not nominate anybody, we served it on his employee.
Yes, his employee signature is also there. And he has received also, he has put his signature in.
No, you say he did not nominate him.
in
Then
the objection, we are going with the objection.
in your own objection, you said that he did not nominate anybody. Then how did you serve it on his employee? You should have served it on his father,
This is the
father, mother, whoever.
Father, mother is in the jail.
Hmm?
Father, mother is in the
yes,
jail.
they were inside the jail at that point
Inside
of
the
time.
jail.
So they could have served him directly there.
Sir, it is.
What purpose
how
would it have
should
served?
sit directly, where they are already in jail.
At least they were inside the jail, and at that time they were also not served. I have
They were in the same position as the arrestee.
Absolutely.
So
But
arrestee has been served section 47.
yes, my lord.
He could do whatever he could with
It-
his 47 notice.
My lord.
So even if you had served 48 notice
My lord.
to the parents
My lord.
who were inside jail,
My lord.
they could not have done anything better.
Do anything.
At least they could have be able to inform somebody in the sense that
That even you could do.
That is why his,
48 is
his employee has. been-
purpose of 48 is that since the arrestee would be behind bars, he may not be in a position to do everything, engage advocate of his choice and everything. So someone outside is better placed to do that.
48
But if
is
that
signed-
person is also inside the jail,
48 is signed by his friend.
my lord, that is why we had drawn this contention. The Honorable CBI Court itself has passed an order granting bail to Sobin Burman, mother and father, citing same reasons, 48, because they have said that they have served someone, some person's name is there, but they have not been able to establish the relationship. Can I show that order, CBI order? That is in page number, in our application, main application, bail application. Annexure equally, my
you
lord.
check if you have submitted it to them in jail. Did you? No. To the parents, you did not.
From the part of the CBI. And moreover, he was arrested while he was absconding there from Goa.
Your page?
Regarding that order.
Just now you said.
Yes,
the
my lord,
order.
page number 180. Annexure equally, page number 180. That is the Honorable CBI Court's order granting bail to father and mother. On what ground? If I'm allowed to read.
That case, it was served on
Yes,
this
some-
Bagodia.
Yes, some Bagotia.
In your case?
We do not know. So that is why, because so
Rajak, his employee.
but the petitioner has nothing to, no relation, or he has not been informed anything about this person. Petitioner also has to know who has,
He is the employee.
whether Dipankar Burman's signature is there.
Yes.
So he has received it.
Yes.
Or then I would take back. If Dipankar Burman has received it himself, then I do not have anything, because this contention was raised from the fact that during the court during the documents were searched and the lower court record was taken into consideration, this factor has not come into the picture. Maybe they had kept it in the CD, that's a different story. So we had raised because we had not found it. If Dipankar has himself, he has received it and he knows, but
Yes.
yes, if he has received,
presence, the signature of witness Mahesh Rajak, below that Dipankar Burman.
it is everything is complied, Your Honor, along with the ground of arrest, in writing, reasons of arrest.
Yes, detailed with.
My lord, then we would like to go from this ground to another ground. We have taken this one because of the fact that we probably thought that maybe like similarly situated condition where father and mother had been granted, because they are co-accused. So since they have been not served, maybe he was also not served because of the fact that he had
Let
himself.
us see if the Granite trial, CBI court had the benefit of seeing the CD.
State police has arrested the patient.
That was arrested by state police.
Subsequently, it is transferred by Supreme Court's order. Then Mr. Dipankar is arrested, and he is arrested from Goa because CBI was in search. And maybe state police has faulted while giving the ground or some. Well aware of
Because learned court has held that prosecution has not furnished any explanation or documentary material to establish the nature of the relationship between the accused and Bagoria. In the absence of clarity as to whether Bagoria was nominated by the accused or is otherwise authorized, requirement of 48 is not there.
But Lordship, one thing is there. No one knows that who is going to be arrested. So prior to that, how it is possible to nominate someone that if I'll be arrested, then you give the grounds of arrest?
No, after arrest, he can say that
Yeah.
you can give it to my somebody.
They might have inquired that he is a known person like.
No, it appears that the learned trial court upon perusal of the record has passed this order and there was no signature of the accused in that notice probably.
Yeah.
Otherwise, it would have been mentioned.
Absolutely.
It is in
So that is in their case, that deficiency was there. So you can't claim parity.
Yes.
They are not claiming parity regarding 48 for that particular sense. Parity we are claiming.
They were granted bail only on that ground.
Yes. No, we are claiming now parity that the co-accused, the other further grounds. That's why we are now moving away from the first ground, Lordship. Because the first ground, our contention was that we have not found that document while we had applied for the certified copies. We do not know now, since it is with them. We had really tried our best to get that notice, but we were not able to know who was the person served, nothing. So we probably thought, taking into consideration of this order, that if the parents could be found to be in this particular condition. So he could be also, because his arrest was very in a different way. He was arrested from Goa, then he was brought back. So whether and our contention was that whether if a sworn arrest also, whether the second agency who is taking that particular case, they will also have to render that particular obligations.
They have.
Yes, yes. So we do not have anything to say now because court is satisfied. Our thing was the court should be satisfied. That's why we have a call for the records as well as for the CD. Now, leaving aside this one, now we go to the merit of the case. At this point of stage, we are basically on the three grounds. The first is that already it is a charge sheeted matter. Investigation has been completed. He is behind bar now for 457 days. At the same time, the last charge sheet, the second supplementary charge sheet was filed on 1/2/2025, almost 1 year. 1/2, 1 year has passed now. Today is 7th. So considering that part, 1 year has passed since they have filed any other supplementary charge sheets. Where if they are
But
proceeding,
trial has not commenced.
no, prosecution has not been accorded.
Sanction is not
No, not accorded. So now this delay, and he has become a person just because his name has been linked with some serious economic offense, which they are already trying to highlight. But in different cases, Supreme Court on earlier occasions in Sanjay Chandra case, they have said that mere economic mere seriousness of the economic offense will not give him the petitioner could be enlarged on paid. So that is one ground, that because of prolonged incarceration, he's behind the bar. Now, okay, fine. If further investigation is going on and if some more arrests needs to be done, because here, if we go to the charge sheet, my lord, almost 395 witnesses are there in part against this particular Dipankar Burman. And again, if they are coming up with more charge sheets, then more witnesses will be there. Now, our fact is that the co-accused, that is the fiancée Mona Lisa Das, she was granted bail on the condition that at that point of time, charge sheet was not filed. So default bail she was granted. Then these two persons, Shovin Borman and mother, they are granted on 48. Now, in his position, we directly cannot seek for parity. But at the same time, we are trying to say that if these persons are already outside now, the fact is that these persons are outside, so they can also hamper and tamper. So only the fact that why he can only hamper and tamper with the witnesses, there is a flight risk, they are saying. Now passport is already with the Honorable CBI Court. So there is no chance that he can go again abscond by going away from this country or fleeing away from the country. The fact remains is that during the initial point of time, his conduct was not good. Maybe because of the fact that he may be advised by somebody else, because there are a number of co-accused are there. In fact, in this particular matter, there is one co-accused, Mukesh Agarwal, he's a chartered accountant. So he is also on bail. So everybody was bail. At that point of time, nobody was nobody was arrested also when this particular thing was happening, and he went. Maybe because of the fact that there was a hue and cry in the media. So we are not trying to say that his conduct was good at that point of time, fleeing away or absconding or trying to evade arrest or any sort of initiation of investigation against him. But the fact remains is that now, since he has passed, he is already behind bar. So for so many days, in the same time, already two supplementary charge sheets have been filed, including his charge sheet. So now what else is remained? And if there is anything that CBI has to say that they are going to file another supplementary charge sheet along with other arrested co-accused part, that is a different story. But our thing is that 455 days, I'm languishing behind bar. Just because they are conducting further investigation, in the name of further investigation, that this will bring so many other discoveries, maybe there or something like that. But the fact remains is that if already the completion of that part, the charges which have been implicated against me, the petitioner, is already over. Already the name of the witnesses are very much there. So how can he go and directly tamper or hamper with the witness? Already the names are there.
What is the nature of the allegation?
Regarding that he has duped the investors by promising them higher returns and by engaging their investment in unregulated deposit schemes. But the fact is that when this particular incident happened, these investors themselves, they came and they have entered into agreement with this particular Dipankar Burman in the name of DV Associates, that is his proprietorship firm. And in that they have said that they have lended him money as loan and they will get back interest. So these particular investors from 2018 till 2024, they were receiving the benefits and they were very happy. Now what has happened is that this particular person, maybe I'm not defending the petitioner, but only saying that he had actually deposited this particular amount through registered brokerage agencies. It is in the charge sheet. All the agencies' names are there. These are registered. These are not like non-registered agencies. But the fact remains is that the charges is that he has used that money. It is not his money. Their money he has directly deposited through that brokerage firms in his name. And maybe this is a crime. That's why he has done it, because he has not got a license. He's not registered under RBI. Now the fact is that in 2024, in the month of April, this whole thing starts after 6 years. Now the fact remains is that because not only this particular, there are so many other also related scams where like most of them are already on bail. Like the famous Sumi Bora case is there. Then you've got Vishal Phukon. So already everyone is on bail. We do not want to make ourselves compared to those cases. But thing is that, yes, it may be a large scale scam of 400 crore as it is shown here. But the fact remains is that whatever documentary evidences or whatever was
Who
needs to
got
be.
the scam money?
Pardon?
Who got the scam money? This
The-
400 crores, who is it? with?
Yes, so now the fact remains is that it will be proved during the time of trial. They have already seized all the documents. Bank accounts have been freezed, everything is freezed, everything. So now we are not into the merit of the case, Lordship, because it needs to be proved during the trial phase. Only we are onto the fact that first contention was 48, now we do not have the 48 since court is satisfied. Petitioner is also now satisfied because maybe he was unaware that he has signed or nothing. But now we are going away from 48 because already court is satisfied. But our next ground is very much important, is that prolonged incarceration, if it is allowed. The fact remains is that 455 days. Last charge sheet submitted on 1/2/2025. One year has already gone back. So whether that particular time is required by the investigation agency to investigate and then to file more charge sheets. If they have got if they have got the
Last charge sheet means supplementary charge sheet.
yes, second supplementary charge sheet against him on 1/2/2025. And in that charge sheet, all the charges are framed against him.
1/2/25.
Yes. So what else is now required? Just because now actually the agency one seem to be there so that they will start the trial and let it be, and later our ground will be whether the petitioner could seek the ground of whether it should be custody trial. Then it will come that one, whether the trial should be in custody. There is a risk that no, if he goes, then entire thing. All the co-accused, Mona Lisa does the fiance. She was the person who was actually, if we go to the charge sheet, she was the person who was getting all the agreements ready and then signed by the investors. Maybe under the direction of Dipankar Burman. Then this mother and father was there involving with the promotion. Mother was there involving with the promotion of the schemes, like they are holding functions. And then this Mukesh Agarwala, very important. He is a chartered accountant. He is absolutely like a person who is having a good financial expertise. Now this person also is there. From 2018, he's involved with Mr. Dipankar. So the fact remains is that if he is also enlarged on bail, this Agarwala, considering his role, because of the fact that he was very much there, he was involved. It is saying that he has manipulated the.
He was released when?
Mukesh Agarwala.
TRS bail.
No. On regular bail. Mukesh Agarwala. We have already given here the order.
Page?
Page number. The order starts with a long order, my lord.
Just give the page number.
Just 163. 13/3/2025, after the charge sheet was filed. He appeared before the learned court below, this is before the CBI court, and CBI court granted him bail.
Yes, CBI.
Please, your lordship.
If you sit over the sanction for more than a year, how will the court countenance that?
Regarding this one, to proceed with the case,
How will the trial start?
Any
There is a
requirement of
requirement.
sanction?
there is a requirement, I think.
Requirement for public servant only.
There has to be some sanction, approval authority, if I'm not mistaken. I have not got the.
With,
No,
no, not required, your
And
lordship.
why has the trial not started even after 1 year of filing the supplementary charge sheet?
further investigation is pending that, and maybe
there is a
copies are being
sanction is
served
required.
upon those who are present.
Sanction is required, my lord, I know, I need to,
For what?
regarding,
This is Supreme Court given.
no, regarding, regarding starting, like proceeding with the trial and proceeding with the.
What kind of? Nobody is public servant.
No, not regarding the public servant, just some accord is to be there from the, because CBI has been formed under.
It is
the-
permission for
Yes.
investigation.
Ah, yes.
DSP, if DSP Act section 6 is required, but this is transferred from Supreme Court. When judicial order is there, so sanction is not required.
No, question is, why is the trial waiting? Can you investigate for 10 years and the trial will wait? What is happening?
That supplementary charge sheet can be filed at any point of time, even if the trial is going on.
In that case, he must be entitled to bail.
So why trial is not doing, as of now, I am not aware, I have to look into. If your lordship will give me a 1-day time, I will get the information. But as of now, I don't have information. But further investigation is there because all over India, this scam is going on. And this is a 400 crores, 11,000 people are being duped. And the most important thing, your lordship, is that
Their investigation may go on against other people, as against him, charge sheet has been filed.
Yes, my lord, that is.
it can be proceeded. It can be proceeded. They can file a petition to proceed. It may be sometime it happened there, accused is not appearing or they are taking time.
He is
they
in
are-
jail, what is?
My lord,
They
on
are
the,
number of
before the
reasons.
lower court below, the petitioner has taken a stand regarding that to start the trial, but their own prosecution.
No, that cannot be. There are number.
No,
of
they themselves have
petitions are there.
submitted that they are not going because they are going to file again because investigation is going.
That cannot
Yes.
be,
Okay,
lordship.
let's call for the scanned copy of the TCR also then.
But so it will be, date will be given. Then TCR, if it is called, then
Yeah, that will be given then.
I think scan copy is available with your court.
Was it called for?
Yes, on last occasion it was called for, my lord.
Item
10.
10, no.
On
Not mentioned in the cause list at least.
But the order was there calling for the scan copies. My lord, the first order, my lord, this particular honorable court had passed that order. The first order.
Yes, it is there.
Yes, that's right. Already it is.
It heard learned counsel for the petitioner at length. Also heard Kumari learned counsel for CBI. Course of hearing, it has become necessary to ascertain as to why the trial of the case has not proceeded despite submission of the second supplementary charge sheet on 01/02/25. Hence, although scanned copy of TCR was called for by order dated 9/1/26, the same has not been received. Reminder to the learned. Which court? CBI court?
Additional CBI court 3.
CBI court 3, Gauhati. To transmit the scanned copy of the TCR without fail by the next date fixed. Fix it after a week?
Yes, my lord. On a given date, my lord.
Yes, give a date.
19.
Yes.
Keep the CD with you for now. On the next date, you don't have to make the same submissions. We are only on the limited point of, we have already heard you.
Yeah, oh, yes. Just allowing me to place few citations regarding.
Yes.
Regarding.
You can place it on that day.
Yes, on that. Not on 48. 48 is.
Yeah, we have the video clips nowadays.
Yes,
so
yes,
no difficulty.
Yes.